probably heard about the law that allows cases to be thrown out, that allows an accused to apply to have their charges dismissed if their case takes more than 18 months to get to trial, to complete trial in provincial court, or 30 months in Supreme Court. Well, this law is enshrined in Section 11B of the Charter of Rights and Freedoms. It's your right to a trial within a reasonable time. The reason we have these specific timelines, 18 months and 30 months, is because of a decision from the Supreme Court of Canada called Jordan. And that decision has been a thorn in the government's side because they don't want to pay more money to hire more prosecutors, build more courthouses, open more courtrooms, hire more judges, and put more money into the justice system, make sure police are gathering evidence and disclosing evidence quickly, creating effective means of getting material to the accused. They don't want to fund the system. They want to prosecute offenses on their own time. And now, in the new criminal law bill that was tabled by the federal government this week, the government is essentially giving themselves a pass on this rule. They are trying to use a criminal law bill to circumvent your charter-protected rights. In this bill, there is a definition of unreasonable delay that says a delay that exceeds the reasonable time for a person charged with an offense to be tried in accordance with paragraph 11B of the Canadian Charter of Rights and Freedoms. And the court says that a finding of unreasonable delay does not deprive a court of jurisdiction with respect to the offense, the accused, or the offender, and a court shall not, shall is an important word in legislation, it means basically must not, order a stay of proceedings as a result of a finding of an unreasonable delay except in accordance with the provisions of the legislation. And the rules that are required for judges to meet before a stay of proceedings, before the charges can be dismissed for unreasonable delay, require first that the prosecutor notifies or takes reasonable steps to notify any victim of the offense referred to in the application of filing the application. So anybody who's a potential victim of an offense, but there are lots of situations where there are victims that aren't interested in the outcome of an offense. Like, why does Shoppers Drug Mart, for example, if you steal from Shoppers Drug Mart very technically is the victim of the crime. If your case isn't prosecuted in 18 months and completed in 18 months and you apply for a stay, why should Shoppers Drug Mart, a corporate entity, have any say in whether your charges get thrown out? They're a multi-billion-dollar company. This is absurd. Loblaws gets to say whether you get your charter-protected rights in criminal court because we're listening to the victims of crime, even when the victims of crime can be literal billionaire companies. Judge also must take into account whether the case is complex, which is already an exception that exists in the law. There's a complex cases exception. The Supreme Court of Canada wrote about it, and judges have been determining what constitutes a complex case. But it's not good enough for judges to do it. Now Parliament wants to tell us what constitutes a complex case. And specifically, a complex case is based on the number of applications or motions, whether they require scheduling court dates separately or in advance of trial dates. That means any case where a person is arguing their charter rights were breached. If you're arguing in your case that the police collected evidence against you unlawfully and that it shouldn't be admitted into trial, that's a pre-trial application that you bring. And now it's called a complex case because you required a voir dire to determine whether the police violated your rights. That is absolutely absurd. It essentially discourages people from arguing that their rights were violated in order to be able to argue maybe that their right to be tried within a reasonable timeline was violated if down the road they don't have their trial completed within 18 months. Also, whether any adjournments were or will be required to complete any of these applications or motion steps, whether more than one judicial decision was or would be needed to complete the steps, the amount of cumulative court time that was required. So because a case took a long amount of time, it's a complex case. Simple cases can take a long amount of time if there's a lot of witnesses or if there's a lot of evidence to go through. You think about commercial crimes cases, often very simple, but they have volumes and volumes of documentary evidence that it takes time to go through and explain to the court so the court can understand the nature of the evidence. That doesn't make it a complex case, and yet this legislation is trying to create a complex case out of simple cases. Also, the need for trial continuation dates arising from the applications that required more time than anticipated, or applications or motions that were not scheduled in advance of the trial, or any other factor the court finds relevant. Well, applications or motions that are not scheduled in advance of the trial usually happen, not because a case is complex, but because the Crown makes a mistake. It happens because the Crown fails to disclose something and it's discovered mid-trial. Something comes out in the testimony of a witness that the Crown knew about and didn't let the accused know about, and now that has to be investigated. I have dealt with so many cases that would meet the complex case definition that are really, really straightforward cases simply based on how this definition is being applied. And the reason that they're creating these rules specifically around these pretrial applications and motions is because of SA cases. They're worried about SA cases that have been thrown out for unreasonable delay because Parliament created a more complicated procedure where there are numerous pretrial motions and often motions that end up having to happen mid-trial in order to determine whether you can ask certain questions of a witness, whether you can do certain evidence, all this type of stuff. And this often doesn't actually happen in the early stages. But this bill doesn't make that better. This bill also says that there's going to be more steps taken in these cases. And the court also, or the Parliament also, is excluding sexual offense proceedings when there are applications for unreasonable delay. The court is not allowed to take into account any of the applications that are made that have been added by this bill or by the earlier bills that have changed the legislation. So they made the cases more complex, and now they're saying subtract all of that time because we actually can't handle, in the system that we have, the law that we created. We cannot accommodate the law we created, so we're not going to count that towards your rights, even though you're the one paying, you're the one prosecuted, you might be the one languishing in a jail cell if you've been denied bail, especially with the new bail bill, and you don't get to argue your rights were violated because the law says we just don't count time. It just doesn't exist. This is absolutely ridiculous.